And I also gave corresponding leave to the applicants to file supplementary affidavits if there was need to do so. So when this matter came up for hearing this morning, counsel for the respondent, Mr. Waititus, had not filed his grounds of opposition, but informed the court that he had filed and served submissions on the other parties. And he asked for time to file the grounds of opposition, which was contested by the counsels for the applicants. Mr. Nyaberi, one of the counsels for the applicants, strongly opposed and urged the court to treat the application as having been unopposed because there was no response filed to the application, and he termed the request by Mr. Waititus as a delaying tactic to have this matter, the application heard, which submission was supported by the other counsels for the respondents, Mr. NDUNG'U, Mr. Swaka, and Mr. Okel, on the same grounds, and the fact that their clients have, especially the applicant in E006, has been ailing since he was incarcerated. So I've considered the application and the submissions by counsels. And the question that I asked myself as I was interrogating the submissions by Mr. Waititus is, why would a counsel file submissions and list of authorities if indeed he was not intent on opposing the application? So in summary, I've found in favor of Mr. Waititus' application. If he had not filed any documents, then one would say he did not intend to oppose the application. But I looked at the submissions. He took time to do the submissions, and he has filed a list of authorities. Then that would mean that he was intent on filing the application. And he has blamed the failure to oversight on the part of his assistants, which I'll take as a good explanation. And in the interest of justice, and Article 159 of the Constitution, which commands us not to sacrifice justice in the altar of procedural technicalities, I've allowed his request to file the grounds of opposition. As I was in chambers, the court assistant brought the grounds. He had already filed the grounds of opposition. I do not know whether he has served the other parties. Have the other parties been served? Yes, because a copy was retrieved from the city. Yes. Oh, you have been served.
Yes, sir.
Okay. Mr. Nyamberi, you have not been served?
I've not had the sight of the same, but because I've just walked in.
Ah, okay. Yeah, because the others were served, and they are fairly straightforward grounds of opposition. I do not know. Okay, for those who have looked at the grounds, do you feel you need to respond by way of supplementary affidavit, or can I now give directions on the hearing of the applications? Counsel for the applicants. Yes.
We have 2 minutes and we caucus.
Yes.
And we give you a uniform decision.
Yes, take your 2 minutes, because I want us to hear this matter, these applications expeditiously. Yeah? So you consult. I'm seated here. I'm not going to take a break. So take your 2 minutes. Yes.
And Mr. Swaka,
Okay.
as the only counsels to argue for all the applications.
For all the applications.
Yes.
Okay. Mr. Waititus, you are ready?
Proceed. I will.
Submissions, because what I get from Mr. Omari is that parties would wish to proceed by way of oral submissions.
Yes, my lady, what I'll do is highlight our submissions. I don't think their choice not to file submissions will prevent me from filing, but so that we are fair to all of us,
Yes.
they can proceed orally,
Yes.
and then I will highlight what we have filed.
You will highlight your submission.
Yes, which is equivalent to just oral submissions.
Okay.
So the court will rely on our submissions, but
Yes.
I'll highlight.
Okay.
Yes.
You have served all the parties?
I have,
You have been served
except
with the
Mr.
submissions?
Okeyo. I can give him a copy of mine.
Will he have time? Okay.
Yeah. We have had a chat earlier, and he agrees that they are related and the issues are pretty straightforward. So maybe it could go last. But now that there is already indication that only 2 of them will proceed, there is no prejudice on the South.
I'm taking it that the quorum is the same as in the morning?
The quorum will
In E006
Yes.
applies to Mr. Okeyo's application.
Okay.
E008.
So the grounds that you have filed are in respect
Grounds
of...
plus submissions plus the list of authorities in
Okay.
E006 applies to E008.
Okay.
Yes.
I do not think there would be a problem with that because we consolidated the matters,
Thank you,
but
thank
I'm
you.
going to put
With the
that on
consolidation,
record
that's
for,
okay.
for
Thank you,
purposes
thank
of
you.
record.
Could we do is the applicant's application or applications for E006 dated 14th of February this year. For E007, is it same date? Same date.
Same date.
E007 same date, so is E008 of this year. My lady, the commonality in these applications is that all of them seek for the orders that the Honorable Court be pleased to grant the applicant bond pending the hearing and determination of their appeal. And the second one, the bond terms as presented or as presented by the applicants before the Chief Magistrate's Anti-Corruption case number 22 of this year, which gave rise to the appeal. Those terms do apply hearing. My lady, this application is supported by the affidavit of the applicant or applicants, and the commonality in them all is that, my lady, they have respectively filed their appeals against the judgment of the subordinate court and sentence which was meted on them. So that we don't deprive the appellate court, which is going to hear and determine the issues that it's going to process, my lady, we will only delve on 2 issues that we need to address on so that the court can consider granting the application. Issue number 1 is the speciality or the exceptional outstanding issue that the 3 appeals raise before court. And the second limb that the court need to consider is whether there is respective appeals filed. I do confirm to the Honorable Court that indeed there are appeals and which raise grounds for consideration on appeal. My lady, just a singular aspect to whether that appeal is or stands a chance to succeed during the argument thereof. My lady, the grounds as raised are weighty. They raise substantial legal issues. They attack the evidence both in law and fact. the evidence and determination by the subordinate court, delving both in law and fact. And those are the issues that we are going to determine. For appeal number 006, the petition of appeal is dated the 13th day of February this year. The petition is dated 13th of February this year. The petition for E006, E007 and 08 is dated
17th February.
17th February, and E008, 18th February. E007 is 17th, E008 is 18th of February. My lady, when we shall be granted an opportunity to argue that appeal, it is our submission that the grounds raised thereat are so overwhelming as to find faults in the manner that the evidence before the subordinate court was analyzed and determined. And arising out of when we shall be raise substantive grounds which stand overwhelming chances of success upon determination. They are not grounds just have they are not grounds that have not just been placed there for the sake of it, but they raise legal issues. We are talking of an incarceration of the applicants, which vary from one applicant to the other. The way these courts operate is that it's going to take fairly some time before this appeal could be fixed and admitted for hearing. Now, the pertinent question that therefore arises is this period between now and the time that the appeal is going to be admitted and fixed for hearing, the applicants will be in custody. Of course, they have been given alternatives to incarceration, but my lady, the alternatives are hefty fines, which by any stretch of imagination cannot be actuated by the respective applicants. So that the delay in processing the appeal and in the end, when this appeal succeeds, the applicant shall have suffered unduly. Their incarceration shall have been illegal. because they shall have been serving an illegal incarceration. I need not to belabor on that point, my lady, because the appellate court is going to have time to process that. Allow me to briefly then scratch through on the second issue. That is the issue on the special circumstances that exist for consideration of the applicants before you. The commonality, again, in their respective affidavits will indicate and show that these applicants are all having challenges with their health. For the applicant in 006, we have exhibited for applicant in 006,
I just want to very quickly rush you through the ingredients to grant of this particular reprieve. Number one, the appeal must have overwhelming chances to succeed, which I do concur, that these appeals will and must succeed. On all grounds, my lady, we've annexed petitions of appeal or memos of appeals which disclose grounds pertinent enough, my lady, not only to interrogate the decision of the learned magistrate, but also to interfere both with the conviction and the sentence. Some of the grounds include the fact that a section of accused persons who formed a part of the chain were basically let go by the High Court. They were acquitted from these proceedings, from the proceedings of anti-corruption 19 of 2020. In particular, they formed the committee that was called the Tender Committee, which basically oversaw this tender being awarded to my client, Charles Chegembudia, alongside his company, Testimony Enterprises. For common intention, my lady, to suffice, we must demonstrate there was a meeting of minds ad idem, and the chain must be so complete. This chain was broken in the first place to be able to point any reference of guilt either to Ferdinand Waititus Babayao or to Charles Chege, or even to the companies that were cited. We've also demonstrated, my lady, that the monies which are alleged to have come from Testimony Enterprises to Ferdinand NDUNG'U Waititus and then to other companies was not Testimony Enterprises, more or less like a kickback back to the governor. My lady, we've been able to fold that finding in the sense that the accounts of Testimony Enterprises already had other monies from other sources, from other works, to the extent that you cannot claim without a shadow of doubt that this is money that came from Kiambu county government through the tender, the offensive tender that is before the court. We've been also able to demonstrate that the learned magistrate himself erred both in law. The learned magistrate erred both in law and in fact. erred both in law and in fact, my lady, by failing, or rather by first and foremost observing that the road was constructed as per the tender, and that actually no money was lost. And that is information coming from a witness who came as a prosecution witness and supported the appellant's case that indeed roads were constructed, money paid was in reference to the roads already done, and in fact, not all the monies were paid to the contractor. In fact, the witness said, Kiambu County government still owes this contractor, who is Charles Chegembudia. We still owe him money. We only paid a little fraction of what we intended to pay. My lady, I file authorities which will guide the court. And in those authorities, I have distinguished, because when you look at the grounds of opposition, sorry? We file them through CTS. They should be in the CTS. We file them this morning. Yeah, we filed them this morning. My lady, we also serve the state. The authorities. Yeah. Yeah. When I look at the digest of authority that I have, first and foremost, my lady, we have referred to section 357, subsection 1 of the Criminal Procedure Code. That gives you all the jurisdiction. 357, subsection 1 of the Criminal Procedure Code. We've given, which basically gives this court all the power, the discretion, and the jurisdiction to release these applicants on bail for grounds that I've cited, and more particularly referring the court to the decision of Jivraj Shah versus Republic. It is with you, my lady, but I'll pass a physical copy to your good court assistant. The decision of Jivraj Shah versus Republic. Jivraj Shah. Jivraj. I will forward the case number, my lady. It was rubbed off from my.
And with the fact that we oppose all the three, severally and jointly, our position is based on the grounds of opposition, submissions, and list of authorities, each dated 20th February 2025, sorry. Lady, dated 20th February 2025. My Lord, in opposition to the consolidated application, we admit to this court's jurisdiction as presented by the applicants under section 357(1) of the Criminal Procedure Code. That this court has both jurisdiction and power to grant bail pending appeal. That is admitted. I'm just, my lady, I normally start from admission, so the 357 came up. So we are conceding that 357 is applicable or as a build-up. However, the question before this court is whether any of the applicants has met the threshold for the grant of bail pending appeal? That is the question before you. And my lady, that is not a new question. You've seen at least 10 authorities from the applicants. It's not a new question in this republic. The question was first answered in 1972. And my lady, the East African Court of Appeal answered that question in the case of SOMO, S-O-M-O, SOMO versus Republic. Sorry, my lady. SOMO versus Republic is reported in 1972 in the Kenya Law Reports. My lady, the decision in SOMO has been restated, and you'll see in a number of the cases quoted by both the applicants and myself, and mainly in SOMO versus Republic, my lady, I just indicated shortly here. 1972 EKLR. That decision has been restated by the courts of by the superior courts of this country, both at the Court of Appeal and the High Court where you sit. I believe this is important. The fact that it has been restated by both levels of the superior courts is important, and this is why. That you are not bound by any of the decisions of the High Court on that question. But my lady, however, you are bound and must comply with the decisions from the Court of Appeal and the East African Court of Appeal. Such that, my lady, if there be a conflict between a decision of the High Court on that question and a decision of the Court of Appeal, you must abandon the decision of the High Court and pick up the decision of the Court of Appeal. And I'll give an instance. You have been referred to the decision of Moses Lenol Kulal versus Republic before the Lady Justice Kavedza at Kibera. And if I understood counsel well, and I have no reason to doubt Mr. Nyaberi, the fundamental reason why bail was granted on that Moses Lenol Kulal versus Republic, Mr. Nyaberi referred to that. Counsel told us it is E092 of 2024. And the submission was that the fundamental reason why bail was granted was ill health. I know that's a decision of the High Court. Now, the Court of Appeal has answered the question of ill health in at least two decisions which we have referred you to. The decision of Jivraj Shah and Republic has been referred to by the applicant. It addresses the question of ill health. The court will have an opportunity to have a look at the decision. Jivraj Shah versus Republic, already cited by the applicants. That's just an indication of which is the binding decisions on you. All the decisions cited by the applicants are High Court decisions except Jivraj. I have confirmed. And therefore, you're not bound by those decisions. Now, let me take the court humbly to the guiding principles in the grant of bail pending appeal as decreed by the East African Court of Appeal and the Court of Appeal. And the threshold is a two-tier test. Both limbs must be met, my lady. We are agreeable with the applicants as far as the limbs are concerned. We only add that both limbs must be met. Number one is that the appeal must have overwhelming chances of success. My lady, we persuade you that the use of the word overwhelming by the Court of Appeal is not idle. Otherwise, the court would have said the appeal should have chances of success. There's a distinction between chances of success and overwhelming chances of success. And my lady, there's a reason why it has to be overwhelming. Number one, because upon conviction, each of the applicants lost the presumption of innocence. they are not presumed innocent upon conviction. And number two, because of the committee of the hierarchy of courts in Kenya, this court, until you evaluate and analyze the evidence afresh, must hold that the decision of the trial court was proper. There is a presumption of propriety of the decision of the trial court, my lady. It doesn't matter what the applicants are saying to indicate a presumption of propriety of the conviction by the learned trial court. Until this court has had an opportunity to evaluate the evidence to arrive at its own conclusion, the conclusion of the trial court was proper. Now, on the basis of those two...
52B, this is the High Court. And we have moved this court under, among others, Section 357 of the Criminal Procedure Code, which allows you to exercise discretion to grant the orders as sought. Number two is on the court hierarchy. We are coming before you as an appellate court, sitting as an appellate court, but on an application, not hearing the appeal itself. Such that we should spare this court the agony of sieving through, analyzing, and coming up with its own conclusions, because that is the domain of a court sitting on appeal. You are sitting to exercise discretion to grant or not to grant bond, and we are submitting that you have the capacity to grant that bond or bail because you have jurisdiction. And we have presented material that is capable of granting that. Number three, Mr. Whitty has alluded to the fact that the issue, we have not processed in our petition of appeal any grounds of appeal which are impeded to law. A casual glance on appeal number 8 will tell you that ground 3 and 4 speak of the law. That is Public Procurement Disposal Act. Grounds 3 and 8 of appeal number 8. We have attacked, this is obtaining for grant of the bond. My lady, allow me then again to address you on the overwhelming chances of success.
Sorry, my lady. Sorry, my senior. I rarely do this. My understanding of rejoinder is limited to points of law, not a regurgitation of what had already been stated. For example, what seniors just stated now about family ties had already been given, so that we don't go to another round of arguing. Senior can limit himself to what the law says about rejoinders.
Let me finish. Yes, I'm now finishing.
Yes, I think Mr. Whitty has a point.
Yes.
You are only supposed to address any new issues that he has raised in his applicants.
I ignore that. Let me leave that exceptional circumstances alone, because the rest were actually points of law. Now the last one, the overwhelming chances of success, and this also has a bearing to the case law, and that we submit that it should be on a case by case basis. This case may present facts which are special than the other case, and that is what we urge the court to consider, so that then the court finds this application to be of merit and grant the bond. I believe that is all that I was able to capture, and may you find favor in the application that has been presented before you.
Thank you, my lady. Again, on points of law, and again, that's a very persuasive decision. It's not binding upon you in any manner, because as we said, you have the jurisdiction, the power and authority to decide this matter on its own, based on the facts that are presented before you. Again, counsel did rush to inform the court that there are no points of law raised. I wish to equally let the court look at the memos of appeal or the petition of appeal, whatever that is before the court. We've raised points of law. In fact, we say the learned magistrate erred in law and in fact. We brought out those points of law. It's only that as it is at this stage, we cannot go to the substance of the appeal, but we've raised those points of law vis-a-vis the points of fact. My lady, points of law that were before the High Court today. That time will come. But what is before you, my lady, invites you to look at the grounds and and the affidavits we've raised in the applications. My lady, when that is done, this court will conclude that the applicants do merit being released on bail pending appeal. I associate myself with the authorities that had shared with the court earlier, both on overwhelming chances of success and, my lady, on exceptional circumstances. The law has never shifted or departed from those two ambits, which we've laid before you, my lady. Thank you.
Court bends back and see if it can accommodate us any day that is earlier for the benefit of the people in prison. I know the court has a queue, but we are requesting the court to be so kind so that we can know our fate. Thank you, my lady.
So I will deliver the ruling on 3rd of March, 2025.
Much obliged, my lady.
Yeah,
Have a good day.
And you too, and thank you very much. Sorry? In the morning. I deliver my rulings in the morning. And sorry?
Allow physical or virtual?
I don't think there's any need of coming all the way. So can it be virtual?
Yes, it's fine. It's fine.
Fine. But we were thinking that they can also have the fresh air. They come around here and they meet their councils. We might get our fees.
It's also one of the considerations. Of bail pending.
I mean, selfish on our part. Let them come.
Unless you really insist. And I don't know, how will be our diary on that date, and some measures which I'll deal with virtually. So I've raised this for 9:30, so that you clear the code for hearing.
The production of this petition already filed so that they are.
Yes, production orders to issue.
Much.
Just in case I mentioned before the virtual court will take time, so 9:45.
Thank you.
Thank you.